Welcome to the session today. Let's get started. The session today is on what HR need to know about frontier worker permits. And for those of you who don't know, I'm Elaine McElroy and I'm a partner in the Employment and Immigration team at Brodie's. And today I'm presenting this session with Erin McLafferty, who will be delivering the second part. In terms of the agenda, I'm going to outline some background and some key points about the Frontier Worker Permit Scheme. And then I'll touch on who's eligible and what the conditions are that apply if you're applying through the scheme. Erin's then going to cover the application process itself, the benefits of this permit over some other types of visa application, and she'll also finish by touching on, just briefly, some business travel considerations after Brexit, as frontier worker permits is just part of the overall picture of the post-transition period world in relation to work. So starting with some background and key points, the Frontier Worker Permit Scheme opened on the 10th of December 2020, which is why we're talking about it now. It's just been opened up pretty recently, and compared to the EU settlement scheme, which has been open for a considerable period of time, and which everybody kind of knows about because there's been a lot of communications about it, the Frontier Worker Permit Scheme hasn't been publicised nearly as much. So hopefully it's a useful time to get an overview of what it does and who it's relevant for. The scheme was introduced to implement some of the commitments that were made in the withdrawal agreement and the EFTA separation agreement and the Swiss Citizens' Rights Agreement. And those agreements contain protections for, I guess, European nationals who were living in the UK through the EU settlement scheme, but also for cross-border workers. So that's people living elsewhere, but who were exercising their treaty rights to freedom of movement by working in the UK. So that's the kind of background to it. And I mention that because there are reciprocal provisions in other European countries in relation to frontier workers. There may have different rules and whatever that apply, but there are other frontier worker permit schemes in other European countries, which might be relevant for some of you who send people to the rest of Europe. And the rules were implemented or introduced into the UK in a set of regulations, and I've put the details on the slide of what those were. And one of the main points to note about frontier worker permits is that the application is free, so similar to the EU settlement scheme where there's no visa fees. So that's a major plus in terms of this immigration route. And also there's no immigration skills charge payable by an employer who has a frontier worker permit working for them, which again is a major plus. That immigration skills charge is £1,000 per year of the visa for other types of points-based system visa applications, for example. So saving on that is a big plus from the employer's perspective, and from the individual's perspective, they don't have to pay visa costs or costs like the NHS surcharge. So again, another plus point. In terms of who it's suitable for those who want to take up employment or self-employment in the UK. So it's a flexible type of visa that covers both of those categories of work. Some visa applications are restricted in terms of what you can do with it, but that's again good news, and you can also switch between employment and self-employment. But it's important to note that it doesn't lead to residence. It's not intended for those who live in the UK and who want to make the UK their home on a long-term basis. Another key point to note is that there's a relatively short window for applications under this scheme. As I said at the beginning, it only opened in December, and some people will have to apply before the 30th of June if they want to be able to enter the UK as a frontier worker from the 1st of July onwards, because that's the sort of date on which people will be expected to produce their permit at the border if they're coming into the UK. That's not a sort of deadline as such for everybody, in that if you don't plan to come to the UK for work purposes immediately, it may be that you can apply a later date. But for many people, that will be a kind of real deadline if they've been coming and going into the UK for work purposes. And our recommendation would be to get your application in sooner rather than later. There's quite a lot of paperwork that needs to be submitted with the application, which Erin will come on to talk about. So rather than delay, submit that and maybe have some gaps in it, it's best to get the application in soon. And then, as I mentioned, individuals can keep using their passports to enter as frontier workers during this grace period up until the 30th of June, but after that they'll need to have the frontier worker permit to come into the UK, and also that's likely to be needing to be produced for right to work purposes at some point in the future when the rules on that change. And then finally, today's a bit of an overview, but there is detailed policy guidance on UKVI website which contains all of the rules, so it's always worth looking at that or taking advice on particular circumstances. So I'm going to run through the eligibility criteria for the scheme. But before I get into that, it's worth noting that the UK has taken a really broad interpretation of who a frontier worker is. And that's a broader definition than is typically used in a kind of European law context. So it means that it is a visa route that lots of employers will find useful. And there's 3 basic requirements. First of all, the individual must be an EEA or Swiss citizen. It doesn't apply to other nationalities. Secondly, the person must be primarily resident outside of the UK. So it's not for people who are essentially living in the UK. And I'll come back to how that's interpreted under the rules later. And then thirdly, there's this requirement in relation to employment or self-employment. So the person must have been an employee or a self-employed person in the UK during 2020, so during the 12 months before the transition period ended, and then must continue to come to the UK for employment or self-employment every 12 months. So there's a sort of 2-stage test in terms of that. You're looking back on the one hand, do they meet that test of employment in that 12-month period? And that needs to be genuine and effective work, and I'll touch on what that means as well. And then looking forward, do they continue to be a frontier worker? So coming into the UK once in every rolling 12-month period. And it's worth bearing in mind that that 12-month rolling period begins on the first instance of work or self-employment in 2020. So for example, if somebody worked in the UK in June 2020, they'll tick the box in terms of having worked in that 12-month period in the past, but they also have to re-enter the UK for work or employment purposes before June 2021 to tick that box of continuing to come to the UK to work. So that's actually a relatively light touch requirement in terms of work, but there does need to be this need for genuine and effective work. So we'll come on to talk about that. In my next slide, I've mentioned it in the final bullet point there, there's certain situations in which even if somebody doesn't satisfy all of those requirements, they will still be treated or entitled to a frontier worker permit. And those are referred to as somebody retaining their status as a frontier worker. So these exceptional cases are where somebody has stopped working in the UK for particular reasons. That could be due to taking a period of maternity leave or having a baby. It could be due to illness or accident, or due to somebody losing their job or giving up employment in specific cases. So if somebody becomes involuntarily unemployed and they continue to look for work in the UK, or they take up certain vocational training, etc., then they may be treated as what's called somebody who's retained their status as a frontier worker and therefore still eligible for a permit. So it's worth bearing in mind, even if somebody doesn't satisfy those sort of key criteria that I mentioned before, they might still be eligible for a frontier worker permit. But there's all sorts of specific rules about, for example, if somebody has lost their job, how long they can retain that status for. So it's worth checking the rules on that. And there are also particular circumstances due to COVID where if somebody hasn't been able to meet the criteria because of COVID, then that's worked into the policy guidance as being an exceptional circumstance that will be taken into account. I'm now going to touch on the requirement for not being primarily resident in the UK. So you shouldn't be living in the UK as your sort of primary home and what that means. Again, it's quite an easy definition to satisfy. You first of all look at whether the person has spent less than 180 days in total in the UK over a 12-month period. So they're actually allowed to spend quite long, considerable periods of time in the UK and to still satisfy that definition of living elsewhere. And even if somebody breaches that 180-day sort of requirement, you can then look at the second strand of the definition, and if they've returned to their country that they live in at least once every 6 months or twice in a 12-month period, then they will be able to tick that box in terms of living elsewhere. So it's actually quite an easy definition to satisfy. And even then, there's also exceptional circumstances about COVID or illness, etc. If that's been a reason why somebody doesn't meet that requirement of being primarily resident elsewhere, they still might be able to sort of satisfy the requirements. And it's important to bear in mind, they don't need to live in a European country, they can live anywhere else outside of the UK and satisfy that requirement. In terms of other eligibility criteria, I mentioned this requirement for genuine and effective employment. And in terms of what that means, there's no specific number of hours that you have to have worked in the UK to show that you were engaged in genuine and effective employment or self-employment in the UK. But they do look at and ask about how much time you've spent in the UK for what periods and for what hours, and how much of your income kind of relates to that employment in the UK in assessing this genuine and effective test. The guidance says that work must not be marginal or ancillary to their situation as a whole in the UK. So if you only came to the UK for marginal activities like having a one-off interview, going to a one-off meeting, other examples they've provided are if you just came to the UK to negotiate a particular contract, etc., that may not be enough to show that you are engaged in genuine and effective employment in the UK. So there are examples in the guidance about what meets that test and what doesn't. The guidance does say that you don't need to have an actual employment contract in the UK, but you need to be able to demonstrate that there is a UK employer and some form of agreement that you're in the UK to undertake specific tasks in return for remuneration. So it could be that you would be employed by an overseas group company, whatever, but there would be some sort of arrangement to come to the UK to perform work in return for money. I'm going to hand over to Erin, who's going to talk about the application process at this point.
Thanks, Elaine. Yes, so we thought it would be helpful to do a quick overview of the application process for a Frontier Worker Permit. It is relatively hands-off for the employer in the sense that they don't have to do anything in the same way you might have to do for a skilled worker visa. But I guess in a nutshell, the individual will make an online application. They will have their ID verified through the Home Office's ID authentication app, which is available on the App Store. The individual will then have to provide some supporting paperwork to show that they are a worker or a self-employed person. And then the outcome, if the application is successful, is usually received in an electronic format similar to the EU settlement scheme. And there are some limited circumstances where an individual would receive a physical permit. Where the employer may get involved in this process would be if the individual requires paperwork to evidence that they are a worker, and quite commonly they will have to come to their employer to get that. And I guess the documents that you have to send need to show 4 or 5 main things, and they're on the slide there. So UKVI want to know whether there is a genuine employer and employee relationship. And as Elaine mentioned, that doesn't need to be with a UK entity necessarily. So it can be with an overseas employer. There is then whether there's a contract of employment in place specifying that the employee is required to carry out work in the United Kingdom. And then they'll look at things like the number of hours worked in the UK, the frequency of that work, and the apportionment of the individual's earnings to the tasks that they're required to carry out in the UK. And it could be in some cases that the contract of employment in place is enough and it ticks all those boxes, but more often than not, a letter may be required as well from the employer just to confirm any kind of uncertainties in relation to those points. So now that we've looked at the Frontier Worker Permit, we thought it would be helpful to highlight the benefits of it. As we mentioned, it is a useful route for EEA nationals who work in the UK but who live elsewhere. It's also a big benefit for those that are familiar with the visitor rules. If you have individuals coming to the UK as a visitor, there's sometimes a bit of uncertainty about when someone is crossing over from being a visitor to a worker. If you have a Frontier Worker Permit, you don't have to kind of worry about crossing those boundaries because working is permitted. And also a Frontier Worker Permit allows you to be in the UK for longer periods of time than a visitor may be permitted. So it just removes that uncertainty and any kind of concerns and gives you the comfort that the individual should be able to carry out most tasks in the UK for longer periods. Another big advantage to the Frontier Worker Permit is that there is no cost, and there are significant savings for both parties, particularly the employer. So the immigration skills charge won't be payable, and the individual themselves won't have to pay visa fees or the immigration health surcharge. And that is quite significant savings when compared with the skilled worker route, for example. The permit is also granted usually for a period of 5 years, but it can be for 2 if the individual has retained status, as Elaine explained. The permits can also be extended indefinitely, which is a really big advantage, but it is a requirement that the individual remains a Frontier worker to be eligible for those extensions. So I guess if the individual stopped being a Frontier worker, then I guess they would lose the permit as well. And also, just, we've touched on this before, but it is a flexible route for employees and employers. The individual can switch between employment and self-employment under the same permit, and it's not tied to any specific employer or job, so that is a big advantage. So why might you choose a Frontier Worker Permit for your staff? So there are lots of visa options out there, particularly for EU nationals who also have the benefit of the EU settlement scheme. And a lot of employers may first look to the EU settlement scheme for staff they require to come to the UK who are European. And I guess the settlement scheme does have quite a few benefits, particularly that it leads to permanent residence in the UK and that it allows the individuals to be in the United Kingdom for an unlimited time period, which compared with the Frontier Worker Permit, which only allows a certain number of days in the UK, or a requirement to always be returning back to the country of residence. So it is more flexible in that sense, but we do anticipate eligibility for it will be limited for kind of textbook Frontier workers, because they're likely to have not been resident in the UK before the end of the transition period, and that is what is required for qualification under the EU settlement scheme. But even where that's the case, an individual may still qualify for the Frontier Worker Permit, and that is still likely to be preferential to options under the points-based system, such as a skilled worker route. And that mainly comes down to factors such as cost and flexibility, because as I mentioned, the Frontier Worker Permit is free and the costs are significantly lower than the skilled worker route. It's also worth bearing in mind that for individuals that you have coming to the United Kingdom for work purposes on a very occasional basis, the visit rules are always worth considering. But as I mentioned, where there's a bit of ambiguity between whether they're doing business visitor activities or working, the Frontier Worker Permit is likely to be more suitable and just give you the comfort that no one's overstepping the mark in terms of activities or time. And while we're talking about visitor rules, we thought it'd be helpful just to quickly finish up talking about business travel and the impact of Brexit. As a lot of you will probably know, the United Kingdom and the European Union reached an agreement just before Christmas in relation to the ongoing relationship between the parties. It's called the Trade and Cooperation Agreement, or the TCA, and within that there were some reciprocal provisions agreed in relation to business travel. It took effect from the 1st of January, but it is still subject to European Parliament approval, which is, we think, coming this month in February. What it essentially means is that British citizens will not need a visa to visit the European Union for up to 90 days, and EEA citizens can travel to the UK under the visitor rules that we have in place. They were tweaked to take into account some of the agreed points in the TCA, but the visitor rules do allow individuals to enter the UK for up to 6 months, so that's good news, although in most cases trips should be shorter than that. There's also an agreed list of activities within the TCAs that business visitors can carry out across the EU and the UK, which is helpful and gives some consistency across the board. but it is important to know that some countries have derogations or exceptions to that agreed list. So local advice may be needed, and it's worth bearing that in mind depending on where the individuals are travelling to. The TCA also had some reciprocal agreements on intra-corporate transferees, contract service suppliers and independent professionals, and I won't get into what that specifically means, but it's just a flag that individuals you are sending, or British citizens that you are sending to Europe, may qualify under some of the TCA provisions. The United Kingdom have implemented these provisions through our current intra-company transfer route, the temporary worker provisions, which was formerly Tier 5. And I guess the main point in all of this is that prior to the end of the transition period, so before December last year, we never had to worry about what we were doing in Europe. Freedom of movement meant British citizens could work or visit without any restrictions. But now that the transition period is over, freedom of movement has come to an end, and UK employers sending staff to Europe may just have to give consideration to the tasks they'll be carrying out and whether a permit will be needed to do that. So I guess that's a whole new thing that's just worth bearing in mind. So just to finish up then, and some key takeaways, the Frontier Worker Permit is now live, and there are significant benefits in relation to cost and flexibility. One thing to bear in mind about the Frontier Worker Permit is that there is no option to settle in the UK, so it will always require an individual returning to the country that they normally reside in. There's also a short window to apply, so up until the end of June, Frontier workers can enter the UK with their EU passport, but from the 1st of July they are going to need the Frontier Worker Permit in place to continue that pattern of work. So it's important to be raising awareness within your business to relevant employees, check whether you think they'll be eligible, encourage them to apply if so, because it makes sense for them to get the permits in place ASAP to make sure that they're ready to come to the UK as a frontier worker from the 1st of July if required. It's also worth identifying if you have any cross-border workers in your organisation. A typical example of that would be if you had an office in Northern Ireland and you had European employees living in the Republic of Ireland but travelling to Northern Ireland for work. That's a kind of typical scenario where a frontier worker permit may be required and going forward. So it's just worth having a think about how your business is structured and any staff that may be impacted or require a frontier worker permit. While the process is still quite straightforward, it is more complex than the EU settlement scheme, and that's because evidence of work or self-employment needs to be sent to UKVI, and the timing for process is still to be confirmed just because it's such a new category. Also, one thing just to flag is that right to work checks have not changed because of the end of the transition period. EU passports continue to be acceptable up until the 30th of June. So it is possible you will have frontier workers coming to the UK and working here legitimately with their EU passport, but it makes sense to encourage those employees to go ahead and apply for their frontier worker permit ASAP, just because it means that you then have the certainty that UKVI and the Home Office have checked that they are in fact a frontier worker. It gives them the ability to travel without any issue after the 1st of July, and it just reduces any risk of there being any illegal working considerations going forward. So that's the end of the webinar, and we'll now open up to any questions. There is a Q&A box, so if you just want to pop any questions you have in there, we can take those.
So I think the first questions come through, which was about timing, which you just sort of touched on in the end, in terms of how long the application process takes start to finish. Do you have a sense?
So the application process itself is online. It is quite straightforward, so the physical part of filling out the form shouldn't be too taxing. In most cases, individuals will be able to have their ID checked on the ID checking app, which is pretty instantaneous and again very helpful. Some individuals may have to go to a visa processing centre to have their applications or their identity checked, and that might add a bit of time on compared with those that use the app. But in terms of processing time, once that's all done, we don't yet have a totally clear picture of how long it's going to take, just because applications have just opened, and we're kind of waiting for that information to come through.
Yeah, and I think whereas I guess the EU settlement scheme applications in some cases have just taken a few days, in this case, because people are having to submit that supporting paperwork, so showing what activities they've performed in the UK, and there's different guidance, I think, for those who are establishing employment as compared to self-employment. If it's self-employment, you have to send in things like invoices and proof that you've been sort of engaging in business activity in the UK. I guess that may take caseworkers a bit longer to kind of go through, and if they come back to you, which they can do, to ask clarifications and things, then there might be a little bit of time involved in that. So I think it's likely it may take a bit longer than some of the EU settlement scheme applications have taken to process. But the main message, I think, is just to get the application in sooner rather than later, especially if you need people to be able to come in from the 1st of July. If it's somebody who comes very occasionally, it might not matter so much, but yeah, I wouldn't be sort of hanging around for the deadline. Do you have any other questions coming through, Erin?
Yep, so one of the questions we've had is, can a frontier worker bring family members with them to the UK?
So the family members cannot apply sort of through the frontier worker permit route themselves, but there might be other immigration routes that they could consider. So some of the options might be to look at the EU settlement scheme or whatever. If somebody wanted to bring family members, you'd need to assess whether they qualified through an alternative route.
Yeah, and I think some family members may qualify under the family member route of the EU settlement scheme, so it is worth checking that if that's critical to a member of staff. Another question we've had is, do applicants need to send hard copy documents in the post, because that might be quite difficult with the current COVID situation?
So I think the guidance on this is that they'll accept scans in most cases of most paperwork, apart from that, apart from the sort of verification of somebody's ID and nationality, then they will generally accept scans unless they've got a particular concern about a document. If they doubted whether it was genuine or not, then they can ask you to submit originals. But yeah, that's good news if they're accepting scans, and I suppose that does also speed up the process a bit.
Another question we have had is, what if we have an individual who stops being a frontier worker during their 5-year permit? Are they able to just pick back up with the unused time on their permit until it expires? And I suppose in relation to that, you only retain frontier worker status for as long as you're a frontier worker. So even if you have a permit for 5 years, if 2 years into that permit, you stop working in the UK, you are required to inform UKVI about that, and then they will take any action they see necessary, whether it be curtail your permit or whatever it may be that they need to do. So staff would be obliged to inform the Home Office of that. They can't just keep using it necessarily.
Yeah, and I suppose that's assuming, yeah, there's no retained status rights there. And somebody's asked, can I clarify, will there always need to be an employment relationship in the UK to qualify? Yes, so that, and I don't think that means the person has a contract of employment with a UK entity, but there has to be a UK employer, and there has to be a relationship of sorts there for somebody to qualify under the employment provisions anyway. There are obviously separate rules for people who are coming to the UK on a self-employed basis. But if you're coming under the employment provisions, yes, there will be a UK employer, and that's, I guess they want something like a letter of support or whatever from the UK employer saying this person comes however frequently for whatever activities and purpose, and that will demonstrate that genuine and effective employment in the UK. But yeah, it doesn't mean they need to be on the payroll of the UK employer, or that they need to have a precise sort of contract of employment with it, but some sort of employment relationship, yes. That looks like we're just about out of time. I see one other question coming through just there. If you want to put your name on, we can drop you a note afterwards, because it's just about past. So thanks everybody for joining today, and we'll send the recording on to you. And if you think of any further questions later, our contact details are on the slide there, so please do get in touch. Thanks.